Hello everyone. In the last presentation, the circumstances under which the defense of act of God, inevitable accident, necessity, mistake and private defense can be pleaded have been explained. In this presentation, an attempt is made to explain the remaining defenses that can be pleaded in an action for tort. Consent. Giving consent to an act implies that the person exercises his judgment and agrees to take the consequences of the act without complaining about it. Consent to suffer harm is a defense available for an action in tort under certain circumstances. Consent has to be free consent, and consent is not free when it is influenced by anger, intoxication, ignorance, deception, compulsion, or undue influence. The maxim that expresses this defense is Volenti non fit injuria, which means that to a willing person no injury is done, or in law, no wrong is done to a person who consents to undergo it. When a person voluntarily agrees to suffer harm, he cannot subsequently complain about it because a man cannot enforce a right which he had voluntarily given up. The maxim applies when it is proved that the plaintiff knew the risk and consented to take the risk. But consent cannot be pleaded as a defense when there is negligence, that is, want of care in doing the act. When a person is placed in a situation where both the options available are dangerous and he chooses one of them and is injured, the doctrine of alternative danger applies. That is, the plaintiff cannot be said to have consented to suffer the harm. The maxim is also different from contributory negligence. In contributory negligence, the defendant does a wrongful act and the plaintiff suffers injury not only because of defendant's act but also because of negligence on his part. Whereas in the case of consent, the defendant does the act on the consent of the plaintiff, knowing that it is likely to cause harm to him. The maxim is volenti non fit injuria and not scienti non fit injuria. Scienter is knowledge, and knowledge of danger is not sufficient. Appreciating it and consenting to suffer it should be present. Consent is a voluntary act of comparing, choosing, and assenting. Knowledge or information does not amount to consent. Consent may be express or implied. It has to be free. Where consent is obtained by fraud, compulsion, imposition, mistake, coercion, misrepresentation, or by administering of drugs, it is not a free and valid consent and will not be accepted as a defense. The maxim volenti non fit injuria is not applicable where there is no consent, or where the consent is not free, or where the consent is to commit an illegal act, or where the consent is to omit performing a statutory duty, or when there is only knowledge and not consent, and when the defendant is himself negligent or undertakes unnecessary risk. In the case of plaintiff's contributory negligence, he will not be allowed to claim damages for the damage suffered by him. Statutory authority. Statutory authority can also be pleaded as defense against tortious liability. What is statutory authority, or what are statutory authorities? They are created by a statute to perform certain specific functions for which powers are conferred on them by law. When they are not allowed to exercise these powers, legal action would be taken against the person who obstructs such exercise of power by the authority. The authority conferred on the statutory bodies may be absolute or conditional. Where the authority is absolute, as the act has to be performed at any cost, no action lies, even where the act causes injury to anyone. Military operations or exercises are an example of such authority. Where the authority is conditional, it is only a permission to do an act, and in such cases where the act is done without using proper discretion, an action would lie. Example, when powers are conferred on a municipal authority to construct a hospital, and the authority chooses a residential area to construct a hospital for infectious diseases, statutory authority cannot be pleaded as a defense in an action for nuisance against the statutory authority. Where the act is done out of public necessity, intentional damage or injury can be caused to others without any liability for it. The same principles are applicable in India also. Judicial and quasi-judicial acts. Judicial and quasi-judicial acts also are exempted from tortious liability. Acts done by judicial officers in discharge of their judicial duties are exempted from liability. This is necessary to enable the judicial officers to discharge their judicial functions without fear or favor. If they are forced to perform their functions under fear of prosecution or civil action, they cannot deliver independent and impartial justice. So far as India is concerned, the law in respect of judicial officers is contained in Judicial Officers Protection Act, which provides exemption to judicial officers from liability for tort. According to the provisions of the Act, a judge, magistrate, collector, or any person acting judicially is exempted from civil liability for acts done in discharge of judicial duty, whether within or outside the limits of his jurisdiction, provided he believes in good faith, that is, after exercising proper care and caution, that he had jurisdiction to do the act complained of. So far as quasi-judicial acts are concerned, they are acts which are not strictly judicial but involve exercise of discretion of authority and have certain civil consequences, that is, they affect the rights of individuals. These acts are also exempted from civil liability if they follow the principles of natural justice and the rules that determine their jurisdiction. The common principles of natural justice are: no one can be a judge in his own cause and no one can be condemned unheard. Even the executive officers are exempted from civil liability for acts done by them legally by proper exercise of their duties. Parents and persons who stand in loco parentis, that is, who stand in the position of parents, have authority over children. Parents have a duty to maintain the child and a right to care, custody, control, correction, and chastisement of the child. These rights have to be used with care and caution, moderately and reasonably for the benefit of the child. Quasi-parental authority also has to be exercised reasonably for correcting what is evil in the child. So far as India is concerned, a parent as well as a teacher have a right to administer moderate and reasonable chastisement for correcting the child and for inculcating discipline in the child, and therefore they cannot be sued for any injury that is suffered because of such chastisement. Finally, a court will not take notice of trivial matters and will dismiss the suit immediately. The defense is governed by the maxim de minimis non curat lex, which means that law will not connect itself with trivial acts. But where the act of the defendant results in infringement of a right which is actionable per se, even where no damage is suffered by the plaintiff, he can sue the defendant and the defendant cannot plead this defense. In torts, the plaintiff has to prove that his legal right has been violated by the defendant, and it is for the defendant to adduce evidence to bring his case under one or more defenses discussed above. This, in brief, is about the various defenses that can be pleaded for an action in tort. Thank you.